Legal English. English is the dominant language of international business relations, and a good working knowledge of the language is essential for today's legal or business professional. Legal English provides a highly practical approach to the use of English in commercial legal contexts and covers crucial law, terminology, and legal concepts. This video offers a comprehensive overview of legal English as it is used in modern, international legal practice. It is principally aimed at legal professionals, law students, and others whose first language may not be English but who regularly deal with legal documents written in English. It constitutes a concise and practical reference resource that will help you both to understand English legal language as it appears in contemporary written and verbal context, and to use clear, accurate English in everyday legal and business situations. Part 1. Introduction to Legal English. The development of modern English. The English language contains elements from many different European languages, and it has also borrowed words from a wide variety of other languages. It is impossible to grasp how these influences affect the language without knowing a little about the history of British Isles. Prior to the Roman invasion in 55 BC, the inhabitants of Britain spoke a Celtic dialect. Latin made little impression until St. Augustine arrived in AD 597 to spread Christianity. Latin words are regularly used in English, particularly in professional language. In the legal profession, Latin phrases like inter alia, among others, and per se, in itself, remain in current use. Subsequently, the Angles, Saxons, and Jutes invaded the British Isles from mainland Northern Europe. The language they brought with them forms the basis of what is known as Old English. These give us the most commonly used words in English language, words like God, man, land, bread, fish, beer. A simple comparison with their modern German equivalents, God, man, land, broad, fish, beer, indicates their common origin. The Vikings began to raid the northeast of England from Scandinavia from the 8th century onwards. At a later date, other numerous place names in northeast of England and Scotland ending in by, Thorpe, Wick, Ham, and in words such as egg, husband, loaf, take, knife. In 1066, the Normans invaded from northern France and conquered England. Words such as court, parliament, justice, sovereign, and marriage come from this period. Later, the English helped themselves initially to further words from French such as chivalry, bourgeois, elite. As the British Empire expanded, further opportunities to borrow words arose. Words such as taboo and paka came into the English language from that period. The result of this multiplicity of linguistic influences is a rich and diverse language with a complex grammar and many synonyms. For example, a coming together or two or more people could be a meeting or gathering. Old English. Assignation or encounter, Old French. A rendezvous, rally or reunion, French. A caucus, Algonquin. A powwow, Narragansett or tryst, Old French. Matters are complicated still further by the fact that from the 17th century onwards, the process of colonization began in earnest. Starting with Ireland and then moving outside the British Isles to North America, Australia, the West Indies, India, and numerous other territories, colonial influence and with it the English language began to spread around the globe. Colonial rule largely collapsed after World War II, but English in different forms and dialects persists as the national language or an important second or third language in many countries. The English spoken in one country may be quite different from that spoken in another. Because of this, it is perhaps possible to speak of Englishes rather than English. Differences between the written English used in one country and another are less marked than those that exist between the types of spoken English used, but there are significant variations, in particular between British and American English. Sources of legal English. Legal English reflects the mixture of languages that has produced the English language generally. However, modern English owes a particular depth to French and Latin. Following the Norman invasion of England in 1066, French became the official language of England, although most ordinary people still spoke English. For a period of nearly 300 years, French was the language of legal proceedings, with the result that many words in current legal use have their roots in this period. These include property, estate, chattel, lease, executor, and tenant. During this period, Latin remained the language of formal records and statutes. However, since only the learned were fluent in Latin, it never became the language of legal pleading or debate. Therefore, for several centuries following the Norman invasion, three languages were used in England. English remained the spoken language of the majority of the population, but almost all writing was done in French or Latin. English was not used in legal state that all legal proceedings should be in English, but recorded in Latin. Nonetheless, the use of French in legal proceedings continued into the 17th century in some areas of the law. In this later period, new branches of, in particular, commercial law began to develop entirely in English and remained relatively free of French-based terminology. As the printed word became more commonplace, some writers made a deliberate effort to adopt words derived from Latin with the aim of making their text appear more sophisticated. Some legal words taken from Latin in this way are adjacent, frustrate, inferior, legal, quiet, and subscribe. Some writers also start to use a Latin word order. This led to an ornate style, deliberately used to impress rather than inform. Even today, Latin grammar is responsible for some of the ornateness and unusual word order to legal documents. It also lies behind the frequent use of shell constructions in legal documents. English was adopted from different kinds of legal documents at different times. Wills began to be written in English in about 1400. Statutes were written in Latin until about 1300, in French until 1485, in English and French for a few years, and in English alone from 1489. What makes English difficult? It is said of chess that the game takes a day to learn and a lifetime to master. In similar vein, English is reputed to be an easy beginner's language in which it is nevertheless very hard to achieve native level fluency. Why is this? There are probably four main factors that make English difficult to master. These are: 1. Lack of clear rules of grammar. We have seen that English is a product of various different linguistic traditions. One of the most exasperating results of this is a confusing system of grammar, which is due to the rules of one linguistic tradition being forced to compromise with those of another. English does of course have grammatical rules, but they are complex and sometimes inconsistent. Furthermore, a great deal of English phrasal construction is purely idiomatic and therefore difficult to explain by reference of grammatical rules. The way in which prepositions are used is obvious but baffling example of this problem. 2. Extensive vocabulary. There are many different ways of saying the same thing in English. This is again because English draws upon different linguistic traditions. For example, if you wanted to say that something was legally permissible, you could use the Old Norse, Scandinavian derived word lawful. Alternatively, you could use the Latin derived word legitimate, or if you wanted a more emotive word, you could use the Old English word right. To take another example, when talking about employment, do you say calling, career, profession, employment, job, work, occupation, or vocation? 3. The use of phrasal verbs in English and legal English. For a verb or both, and as noted in point 1 above, prepositions do not always follow clear grammatical rules. 4. The use of idioms. Idioms are groups of words whose combined meaning is different from the meanings of the individual words. For example, the expressions over the moon means happy. Idioms are frequent in ordinary English. They are a distinctive element of the way native English speakers use the language. They are found less often in legal English, but exist in some legal jargon. For example, the expressions on all fours is used to refer to a case in which the legal issues correspond exactly to the legal issues present in previous case. What makes legal language difficult? One of the main reasons why legal language is sometimes difficult to understand is that it is often very different from ordinary English. This arises partly from the purposes for which it is used and partly from certain habits of writing that derive from its historical linguistic roots. The purpose of legal language. The main purpose of legal language is not so much to communicate, to regulate. This is very clearly the case where legislation is concerned, but it's also true of private arrangements between parties that are intended to have legal effect. A contract, for instance, is essentially a system of rules agreed between the parties designed to regulate their commercial relationship or certain aspects of it. It lays down the conditions on which the contract or certain parts of the contract come into effect, states the obligation to which each party is subject, makes clear what each party may or may not do in performing the contract, and contains provisions dealing with what will happen in the event of a breach of contract. Old habits of legal writing. The general trend of modern legal writing reflects a greater effort to resemble ordinary modern business writing. However, traditional legal writing, which stubbornly persists in certain countries and certain types of law, is characterized by a number of odd features. Here are some of them. Sentences often have apparently peculiar structures and wording. For instance, due performance by the employer of the contract in the matter hereinafter appearing means that the employer must carry on the terms of the contract in the way of the contract specifies in the provision lower down in document than this one. The case in documents relating to land, such as deeds and conveyances. Foreign phrases are sometimes used instead of English phrases. For example, inter alia instead of among others, void ab initio instead of invalid from the start. Unusual pronouns are used, the same, the ever said, etc. Unusual set phrases are used, null and void, all and sundry. Semi-archaic, here, there, and where formulations such as hereof, hereinafter, whereas, therein, and hereby remain in fairly frequent use in contracts and other legal documents. Difficult and unfamiliar words and phrases in additions. A large number of difficult and unfamiliar words and phrases are used in legal English. These fall into 4 categories, brief details on which are given below. Legal terms of art. Legal terms of art are technical words and phrases that we have precise and fixed legal meanings and which cannot usually be replaced by other words. Some of these will be familiar to layperson, for example, patent, share, royalty. Others are generally only known to lawyers, for example, bailment, abatement. Legal jargon terms of art should be differentiated from legal jargon. Legal jargon comprises words used by lawyers that are difficult for non-lawyers to understand. Jargon words range from near slang to almost technically precise words. Well-known examples of jargon include boilerplate clause, a standard clause included in a contract that helps define the relationship between the parties but has no direct relevance to subject matter of the contract. And corporate field, the concept that a company has a legal personality separate from that of its shareholders to protect them from personal liability from the company's actions. Legal jargon includes a number of archaic words no longer used in ordinary English. This includes words like annul to declare that something, such as contract or marriage, is no longer legally valid, and bequest to hand down as an inheritance property other than land. It also includes certain obscure words that have highly specialized meanings and are therefore not often encountered except in legal documents. Examples include emoluments, a person's earnings, include salaries, fees, wages, privates, and benefits in kind, and provenance, the origins of early history of something. Jargon words should be replaced by plain language equivalents wherever possible. Legal meaning may differ from the general meaning, reversed, 2. The seizure of goods as security, the performance of an obligation. In ordinary English, it means anxiety, pain, or exhaustion.